One of the most underappreciated dynamics of American political life is that the people who incessantly claim that they are here to save democracy, that they're the only political faction that cares about democracy, that needs to protect democratic values from the fascist and dictatorial onslaught of Donald Trump and his movement, are people who spend most of their time either getting their adversaries and critics censored from the internet or banned from the internet, trying to remove their political opponents from the ballot so that nobody can vote for them, and in the case of Donald Trump, trying to imprison their primary political rival. It's bizarre that the people who are doing those things, those classically authoritarian moves, are people who simultaneously believe and insist that they are the only guardians of democracy. One of the most remarkable events occurred last December, and we covered this at length when it happened, when the Colorado Supreme Court, by a vote of 4-3, decided that Donald Trump ought to be banned from the Colorado ballot, both for the primary and then for the general election, on the grounds that he committed a crime that he's never been charged with, let alone convicted of, which was insurrection. That ruling went to the Supreme Court. Today, the Supreme Court heard oral arguments on it. We listened to it, and by all accounts, not just mine, including liberal outlets, the Supreme Court was overwhelmingly hostile, scornful toward the argument that Colorado has the right to ban Trump, or that any other state does on this ground. Here from CNN today, Supreme Court hears historic case on removing Trump from the ballot. Quote, the justices' questions suggested they may support putting Trump back on the ballot as they expressed skepticism of Colorado's arguments. Chief Justice John Roberts, a key vote to watch, said the arguments are, quote, at war with the thrust of the 14th Amendment. Liberal Justice Elena Kagan questioned the implications of a single state banning a candidate in a presidential election. Now, this is the remarkable part of the ruling, is that two of the liberal judges, Justice Kagan and Sonia Sotomayor, were, I would say, at least as hostile to Colorado's arguments as the conservative justices were, although they were quite hostile as well. Maybe Justice Brown will be willing to rule in favor of Colorado, but I seriously doubt it. But it seems likely that Justice Kagan and Justice Sotomayor will join the 6 other justices, who are generally referred to as being conservative, to deliver at least 8 votes and then maybe 9 unanimously against the Colorado ruling, which would be quite a momentous event for the Supreme Court with that kind of a voice to say that the Democratic Party and the liberal effort, and that's what this was, even though it was brought in the name of several Republican individual voters, it was spearheaded and organized by Crew, which is a liberal activist group that claims to act in the name of ethics in government, even though they are obviously a Democratic Party activist group. It would be extraordinary if they get slapped down, not by 6 justices of the Supreme Court, but by 8 or even 9. Here's an example of Justice Kagan questioning Jason Murray, who is the attorney for these Republican voters that they got to become the plaintiffs in the case, and you'll listen to just how clear her view was.
Most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, you know, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true. I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck. The first mover state here, Colorado, we're stuck with that record. And, you know, I don't want to get into whether the record, I mean, maybe the record is great, but what if the record wasn't? I mean, what if it wasn't a fulsome record? What if, you know, the hearsay rules are, you know, one-offs? Or what if this is just made by the Secretary of State without much process at all?
All right, so you get the flavor there. That is an argument essentially saying that what Colorado did has the real possibility of preventing the person that the country actually wants to elect from getting enough votes simply by making a ruling about the 14th Amendment that has obvious federal consequences that is not the state of Colorado's to make. And while the lawyer for Colorado is saying, well, no, you should make it, the Supreme Court is saying, but you're not actually asking us to make it. We can't make a ruling starting from scratch because we're bound by the factual record of what Colorado did if you were to win. And what if Colorado has a bunch of weird rules about evidence and hearsay, and now we're stuck with this weird ballot that somehow is supposed to govern the entire country and the right to choose a candidate? That was always one of the weirdest parts of what Colorado did, is it's so obvious that this is a federal election, that it belongs on a federal level with Congress or the federal courts, and the judges, not just Amy Coney Barrett, but Elena Kagan, seem very emphatic about that. I mean, this goes on for another two and a half minutes like that. And there is barely an argument raised in favor of Colorado throughout the entire hearing today. And usually that's why, as a lawyer, you go into an oral argument, you come out, you kind of try and read the tea leaves. But a lot of times you think you won, and then you end up losing. Or a lot of times you walk out saying, yeah, I think they're going to rule against me, and they win. In this case, it wasn't hard to see. They weren't pushing both sides. They were only pushing one, and they were pushing them hard. And that was the state of Colorado. Here is Justice Gorsuch, who had a lot of contempt for, actually, this is Justice Roberts first. We're going to show you him, given that he's generally considered to be a swing vote. And let's listen to what he had to say.
But what do you do with what would seem to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot, and it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually we would be deciding whether there was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th since Reconstruction. Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question, which is other states may have different views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong. And maybe they thought it.
The lawyer actually is reminding me a lot of that YouTuber I debated about January 6th, Destiny, who was, I think he thinks he's some kind of like giant of journalism and also a constitutional scholar. He was like so definitive and certain that it's so obvious. You just like read the 14th Amendment. He was saying it's like so clear that Trump can't run. He's guilty of an insurrection. And like the entire Supreme Court is looking at this and saying, this is insane. And just on like the very first issue about whether Colorado even has the right to decide this, let alone on all of the other issues about whether Colorado, if they did have the right to decide, actually made this decision accurately to be able to say, well, Trump wasn't charged with insurrection. He wasn't convicted of insurrection. He never had all the rights of a criminal trial that the Constitution guarantees when you're alleged to have committed a crime. And nonetheless, we're going to just kind of invent out of the air after like a civil and evidentiary hearing the last 3 days that the President of the United States is ineligible to run for office. It is such a obviously anti-constitutional and anti-democratic posture, and it's very relieving to see the Supreme Court heaping this kind of scorn on it. And Justice Roberts is very soft-spoken, but he was being pretty aggressive because he was not getting his question answered in lieu of these kind of like streamer arguments like, well, it's so obvious this January 6th, nothing like it happened before, whereas if anyone else claims it's an insurrection, that would be frivolous. That's like a high school debate argument that none of these justices are even letting this lawyer speak barely because his arguments they don't command any respect or any credence. Here is probably the most hostile of the exchanges, and it was with Justice Gorsuch. You rarely hear any judge treat a lawyer like this, let alone a lawyer that gets to the Supreme Court and is presumably qualified. And this lawyer actually clerked for, I believe, a Supreme Court justice, but for sure an appellate court lawyer. He's a well-regarded lawyer in the legal world, and yet actually clerked for Elena Kagan on the Supreme Court. And you saw how she treated him. So here's how Neil Gorsuch treated him.
It operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
I mean, so this is an important point, which is, the question is, how did Donald Trump become an insurrectionist? When did this happen? And how? By what procedure? Like I said, there was never any process that was given to lay out the case against him. Jack Smith charged him with many crimes. None of them was the crime of inciting or engaging in an insurrection, even that is a crime in the U.S. Code. He could have charged him with that, but didn't. One would think that if Jack Smith thought he could convict Trump on that charge, he would have charged him, and yet didn't. And in that debate, I repeatedly asked why he wouldn't, and finally there was an admission that, well, he probably doesn't think he can get a conviction. Okay, well, that's a pretty significant concession. And so the theory that Colorado invented and that its defenders concocted to try and justify what Colorado did is, oh, you don't need a procedure, it's just automatic. It's self-executing. The minute someone commits an insurrection, they're banned from high office. And they have to say that because Colorado has to admit there was never any procedure, any finding that he committed an insurrection other than Colorado's own process. There was no trial. There were no rights given. And so Gorsuch is going to spend his time trying to understand how it could possibly be that Trump became ineligible for office instantly on January 6th, even though there was no process, just like magically happened out of nowhere. It was self-executing.
You say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment, self-executing, done. And I would think that a person who would receive a direction from that person, the president, former president, in your view, would be free to act as he or she wishes without regard to that individual.
I don't think so, because I think, again, that
What he's essentially saying is, if Trump became guilty of insurrection on the day that he did it, then it shouldn't even be the case that people inside the government would obey the orders of Trump, even though he was the inaugurated elected president, because it's just self-executing. The minute a president does an insurrection, you don't need a trial. It just is like an inherent thing that just materializes in air. This is the Colorado lawyer's argument. And Neil Gorsuch is essentially saying, well, wouldn't that mean that everyone in government can just ignore anything Trump says or does because he's now no longer eligible to be president? He's not even the president anymore by virtue of having committed insurrection. If that could really happen that way, that it's just self-executing, it just materializes.
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is
no de facto. That doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside. Okay. I think Justice Alito's asking a very different question, a more pointed one, and more difficult one for you. I understand, but I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
I'm imagining a situation where, for example, a former president was, a president was elected and they were 25 and they were ineligible to hold office, but nevertheless they were put into that office.
We're talking about Section 3. Please don't change the hypothetical, okay? Please don't change the hypothetical. I know I like doing it too, but please don't do it, okay?
Well, the point I'm trying to make is
he's disqualified from the moment he committed an insurrection, whoever it is, whichever party, that happens. Boom. It happened. What would compel, and I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on. What would compel a lower official to obey an order from that individual?
Because ultimately we have statutes and rules requiring chains of command. The person is in the office, and even if they don't have the authority to hold the office, the only way to get someone out of the office of the presidency is impeachment. And so I think if you interpreted Section 3 in light of other provisions in the Constitution like impeachment, while they hold office, impeachment's the only way to validate that they don't have the ability to hold that office and should be removed.
I mean, I can't put into words how self-destructive that whole exchange is for Colorado's theory. The whole point, as Neil Gorsuch started off saying and then got increasingly frustrated when he couldn't get an answer, was that the only way Colorado can justify what they did is if their view is we don't need a trial, we don't need a conviction, because the minute a person in the office of the presidency engages in an insurrection, they are, from that point on, ineligible to hold that office. And so then the question became, well, why, the minute January 6th happened, would anybody in the government have to obey Trump? After all, they would say, oh, he committed insurrection. He's now ineligible to be president. He can't hold the presidency. And the lawyer's argument was, no, you need a remedy. You need Congress to actually go do something. You would need Congress to impeach him based on the finding that he committed an insurrection. And that's the whole point of the Supreme Court about why what Colorado did was so obviously baseless. Because there never was an act like that, finding that Trump was guilty. There was no act like that from the Congress. Remember, they acquitted Trump on those charges, on the charges of impeachment. There was never any court ruling in a criminal context charging him. Just Colorado just decreed it based on Colorado's little idiosyncratic state rules. And so the minute that lawyer said he wouldn't be automatically rendered powerless as president because he committed insurrection unless you had an act of Congress that removed him, the whole case is gone, because you're then saying that it's not self-executing. You need an act of a legitimate body to determine and decree that he actually committed an insurrection, and that's exactly what Colorado does not have here. It's such a I mean, I want to take note of how extraordinary it is that the strategy of the Democratic Party is to get Donald Trump removed from the ballot, banned from having people vote for him when they're looking at polls showing that the vast majority of Republicans and a majority of Americans, or at least a plurality who vote, want to vote for Donald Trump instead of Joe Biden. And if Trump were convicted of a crime that the Constitution says renders you ineligible, that would be one thing. But to do that in the absence of any kind of a judicial ruling that says that, other than what Colorado decides in its state court system it's going to do, with none of the triggering of protections that a defendant gets when they're accused of a crime, is mind-bogglingly anti-democratic, with no basis in the Constitution, even though a lot of liberal YouTubers and tweeters and the like will insist that it's such an obvious victory for Colorado, that it's so obvious Trump can't win when you finally get non-state judges on the Supreme Court, to take a look at this. They reacted with horror, with kind of shock and contempt. And I hope it is a unanimous ruling, or 8-1, which looks like it could be, because I think that'll be an extremely justified comeuppance for this attempt. Thanks for watching this clip from System Update, our live show that airs every Monday through Friday at 7 p.m. Eastern, exclusively on Rumble. You can catch the full nightly shows live or view the backlog of episodes for free on our Rumble page. You can also find full episodes the morning after they air across all major podcasting platforms, including Spotify and Apple. All the information you need is linked below. We hope to see you there.